The matter before the court is a motion to modify a temporary order in the case in regards to a spousal support order that this court had earlier made. Are you still pursuing your motion to modify at this time, Ms. Thompson?
May it please the court, Mr. Larson is requesting today that the court modify the temporary orders in this matter to change the spousal maintenance so that he not have to pay spousal maintenance anymore moving forward. As the court's aware, temporary orders on July 3rd ordered him to pay $2,500 a month for spousal maintenance, and he was ordered to start paying that on July 1st, 2025. However, the petition was filed on July 1st and a summons was issued on July 8th, and Mr. Larson was not served until after that. So as a preliminary matter, no matter whether or not the court agrees to modify or not, we would ask if the court is inclined to keep spousal maintenance ordered that it state that the maintenance payment not start until August 1st of 2025. So that would allow him to have not missed a payment for July. The main reason, however, that Mr. Larson should not have to pay anything in spousal maintenance is due to the fact that there are 4 reasons. First, petitioner lists in her expenses in her DRA that she owes or has about $1,245 each month that she has to pay. And she's, of course, requested well above that by about $1,300. And so I believe she has greatly overstated her needs in the request. Second, the petitioner has access to joint banking accounts of the parties that have more than $49,000 in total in them. And this includes a savings account that has at least $34,000 in it. All of that is more than enough for her to utilize to pay her monthly expenses while the matter is ongoing. Third, there's no evidence that petitioner has actively sought a job. Mr. Andrews may make us aware of.
Before this hearing even begins, let's break down what's really at stake here. We have a divorce case involving a long-term marriage, a 6-figure investment account, and a battle over $2,500 a month in spousal support. But this isn't just about monthly payments. It's about access control, income classification, and whether one spouse should be required to support the other while sitting on a marital estate worth over $600,000 on one side. Mr. Larson argues his soon-to-be ex's access to tens of thousands in joint accounts and investment dividends averaging nearly $4,800 per month last year. On the other side, Ms. Larson claims she has no actual usable income and should be forced to liquidate marital assets while he continues building wealth.
Frankly, this just belies credibility. Ms. Larson, the petitioner, has had full access to that account with her own login and password since the day the account was opened. She has authority to move the money in the investment account to a joint banking account to pay for bills. And in fact, this was typically done during the marriage by Mr. Larson. Ms. Larson did not do it because she entrusted the finances to him. However, the money from the dividends was used to pay marital bills. It was used to pay for vacations, for taxes, and for other expenses. And the money was reinvested at one point into some stocks, but that has not been done since 2023. So the fact that she's stating in her motion that she didn't know about this while identifying that the dividends come from Brazilian oil stock doesn't really compute. In fact, it's my understanding that Ms. Larson told Mr. Larson when they were getting a divorce that she wanted the investment account because of the great dividends that it pays. So in the motion, we are asking the court to order her essentially to access that money to use as her monthly income for her expenses, if nothing else, even though there is another source for her in terms of the joint banking accounts. The petitioner also stated in her response that she had just recently found out about this account, but her DRA that was filed on July 1st lists the account and lists a full value of $645,658.07, which is a very specific number for someone who didn't have knowledge of it. So I think that the average monthly income from those dividends, which typically is in the thousands, for last year it averaged about $4,800 a month. And it gets deposited, like I said, 8 times during the year. And so she would have access that she already has to take that dividend money that's coming in, move that over to a joint account or whatever account she wanted to set up for that, and then use that to pay for her expenses and her groceries and anything else that she's listed as her expenses on her DRA. And the argument that this would somehow deplete the marital assets, I just don't think flies, because as the court's aware, spousal maintenance is not a right or an entitlement in Kansas.
Right away, the strategy from Mr. Larson's side is clear. Narrow the issue, minimize the obligation, and shift the timeline. They're not just asking to eliminate spousal support. They're also arguing about when it should even begin. That's important because temporary orders often hinge on service dates and procedural fairness. If he wasn't formally served until after July 1st, they're suggesting he shouldn't be penalized retroactively. But notice something subtle here. They're not denying the court has authority. They're arguing fairness and practicality. That's a smart tactical move. Instead of attacking the system, they're framing it as a timing correction plus a larger question. Does she even need the money?
Yes, he made a payment in August for the $2,500 that was ordered.
All right. Anything else at this time, Ms. Thompson?
No, Your Honor.
All right. Mr. Andrews?
Thank you, Your Honor. Your Honor, I'll attempt to address Ms. Larson's points in order. First, with regard to the expenses, the domestic relations affidavit did contain estimates of the current expenses that Ms. Larson was incurring or was expecting to incur, and that shows that there was only a need of $1,245 a month, which is less than the $2,500. However, those expenses, again, were estimates based on the fact that Ms. Larson is in the marital residence, that she has not been the one who has been responsible for the finances during the parties' relationship. And so she was attempting to make those estimates based on what little information that she was able to gather on her own. However, notably, the expenses do not include a rent expense, for example. Ms. Larson the parties are going to be selling the marital residence, so Ms. Larson is going to be incurring some form of expense in order to live in her own place. It doesn't have a health insurance expense because she's currently covered under Mr. Larson's health insurance. There are a number of expenses that are not incurred or not included in the DRA because they're just unknown or haven't been incurred yet. On the flip side, Mr. Larson can easily afford to pay the $2,500 a month that we requested. Based on his domestic relations affidavit, it looks like he has a net balance of $20,908 a month after payment of his expenses. We're asking for $2,500 a month to help support his spouse. We believe that it is not inequitable to ask Mr. Larson to support his spouse. They've been married since 2011. This is a relatively long-term marriage. And Ms. Larson has not worked since 2012 by agreement of the parties. She has remained at home. She does not, to say that it's just easy to go out and...
Now this is where the numbers start to matter. A $645,000 investment account. Dividends averaging roughly $4,800 a month last year. That's not small change. The husband's attorney is essentially saying, how can someone claim financial hardship while sitting on an account generating thousands monthly? But here's the legal nuance. Dividend income can exist on paper without being liquid cash in hand. If those dividends were reinvested automatically, that becomes a debate about accessibility versus theoretical income. Courts often wrestle with this distinction. Is it income if you don't actually receive it?
With regard to the investment accounts, Ms. Larson was aware that there were investment accounts. She did not know that it was paying out dividends. And I think that was the point I was attempting to make in my response if that didn't come through. She found out recently about the dividends, but it's not because she actually received them. In fact, Mr. Larson sent a text message through the party's daughter stating that The dividends are paid out periodically throughout the year. And as he said, I'm quoting here, these dividends were from the Brazilian oil stock that Heather knows about and even said she wanted the stock from it at one point. The dividends we had go back into buying more shares of the stock minus the taxes we owed on the dividends. These amount of dividends last year was $115,656, $57,828 each, $4,819 each month average paid through the year. His theory is that because there was $4,819 each month on average throughout the year last year, even though that money didn't actually go into the party's account, it was either spent on taxes or reinvested, that this is now going to be imputed as an income to Ms. Larson. And again, I'm taking Mr. Larson's own words here. I'm not relying on what Ms. Larson is telling me. So his position is that because there is theoretical income through these dividends, even though Ms. Larson doesn't actually have access to them.
And this is the heart of Mr. Larson's position. Spousal maintenance in Kansas isn't automatic. It's transitional. It's meant to bridge gaps, not create long-term dependency, especially where both parties have meaningful assets. The argument being made is that awarding $2,500 monthly, while she also benefits from future division of a substantial marital estate, would effectively be a double recovery, i.e. divorce litigation. Courts constantly weigh equity, not punishment, not reward, equity. So now the question becomes whether requiring him to pay from his paycheck while she preserves investment growth creates imbalance rather than fairness.
Until final orders of the court are issued, including bank accounts, investment accounts, retirement accounts. And so Ms. Larson is not depreciating those marital assets. Instead, she is asking that her expenses be supplemented by Mr. Larson's income, which is significant and has been used to support her as his spouse throughout the entirety of the marriage. This is, in my opinion, a classic example of a situation where spousal support is warranted when one party has a disproportionate amount of income, the other party either has little income or, in Ms. Larson's case at this point, zero actual income that she could spend that is coming in on a monthly basis. That's what spousal support's for. Again, if the court were to order that she dip into the marital estate to pay for her expenses, we would just ask that that be not taken out of her half of the marital estate. If that's the proposal, they could come out of the full amount, as well as the money that goes back into the estate while this case is pending should be considered as well as increasing the value of the marital estate. Because what really Ms. Thompson is asking is that Ms. Larson reduce the marital estate while Mr. Larson builds up himself a nice little nest egg with the significant amount of income that he's going to be receiving while this case is pending. And we're not asking that he pay hardly any of his disposable income when it comes to this. I mean, it's a little more than 10% of his disposable income, not his gross income, but his disposable income is being requested for spousal support. I just frankly think that the asking to not have to pay anything under these circumstances is...
Now we hear the counterpunch. Ms. Larson's attorney reframes the narrative entirely. Yes, the expenses listed were only about $1,245. But those numbers don't include future rent, independent health insurance, or post-separation realities. That's a critical point. Temporary budgets in divorce cases are often incomplete because life is in transition. And then comes the length of marriage factor. Married since 2011, out of the workforce since 2012 by mutual agreement. That changes everything. Courts take long-term homemaker roles seriously because re-entering the workforce after a decade isn't as simple as just get a job. This isn't just about numbers. It's about earning capacity and lifestyle reliance built over years.
And Your Honor, I would just respond briefly that the parties have brokered an agreement through an auctioneer to auction the house, and she asked to vacate by September 23rd.
Sorry, my client was not aware of that or informed of that, and so we do not know of the auction.
Well, according to McCurdy Auctioneer, they've been in contact with them and they agreed on a price and they agreed on a date. So unless McCurdy Auctioneer is providing incorrect information,
I think they needed to contact your client first, that's all. And so that's why they didn't have a date to give to my client.
All right. Ms. Thompson, anything further to present to the court at this time?
Your Honor, I just would point out that my client's income is sizable, but he doesn't have a specialized degree. And I know that Ms. Larson doesn't have a degree, and so she is just as capable of going out and earning money during this time. And I think the court needs to take that into consideration. And one final point on the health insurance, that's obviously not going to be a concern at all until this divorce is finalized, because we are not asking for her to be removed from the health insurance, and she can't be removed at this point. So I don't believe that should be considered as well. And there is no check that goes out to either party on the dividends. It goes directly into that account, and she has access to that account and should be able to see those deposits.
Here's the technical financial dispute crystallized. Are reinvested dividends income? The husband's own text message confirms the dividend amounts. Over $115,000 last year total. That averages nearly $4,819 per month. But the wife's attorney argues that money wasn't distributed as spendable cash. It was reinvested or used for taxes. This distinction matters enormously. Courts often look at whether a party can actually access funds without violating standing orders that prevent dissipation of marital assets. If she withdraws investment money, is she harming her own share of the estate, or is she simply using available resources?
That's not what Mr. Larson told his daughter.
Well, then that's what I'm telling the court today at this hearing.
All right. Very well. Thank you, counsel. Appreciate the quality of your arguments here today, and the court has had the opportunity to review the contents of the file in this case and to consider the temporary spousal maintenance order in this case. The court will make the observation that, generally speaking, the court looks at the need of one party for spousal maintenance and the other's ability to pay. Here, there's an obvious large disparity in income between the parties. And the court has also considered the fact that the parties do have assets that are, at this point, liquid enough that could be accessed. However, I do understand Mr. Andrews' argument and agree to a certain extent with it, that depleting assets of the marital estate just for purposes of everyday needs does not make sense to this court. Further, the fact that Ms. Larson doesn't have a job at this early juncture in the case shouldn't be surprising. She wasn't working during the term of the marriage, and while the court would look at her employability for long-term spousal maintenance in this case, the court looks at the issue of temporary spousal maintenance as just a question of cash flow. Both parties need cash flow to keep functioning during the pendency of this case. It's intended, as Ms. Thompson recognizes, to be transitional and at this point, temporary. The court, looking at the expense that are listed by Mr. Andrews and his client.
Now we're at the philosophical divide. One side says, don't deplete marital assets. Support should come from the income earner. The other says, both parties have equal access to substantial assets. So why shift burden solely onto one paycheck? The wife's attorney is emphasizing proportionality. He points out that $2,500 is only slightly over 10% of the husband's disposable income. That's designed to make the request sound modest, not excessive. Divorce court often comes down perspective. Is $2,500 a burden, or is it reasonable transitional support after a decade-long marriage where one spouse didn't work? What we just witnessed is a classic temporary support battle. Asset access versus income disparity. Mr. Larson argues that substantial joint investments in dividend income eliminate the need for spousal maintenance. Ms. Larson argues she has no practical, spendable income and shouldn't be forced to erode marital assets while he continues earning significantly. The judge's ultimate decision will likely hinge on three factors: accessibility of dividend income, preservation of marital assets, and the long-term nature of the marriage.